The question be now put.
Grant Robertson.
Thank you, Mr Chair. And I think my colleague Phil Twyford was making some very good points there. And the committee was told when we considering the bill that the quantum that the Inland Revenue Department thought they would be able to gain from the Bright Line test hadn't changed from what we'd been initially told, which was the whopping sum of $5 million a year. They also included in their assessment to us it was going to cost about $2 million to set the whole thing up. So things are not looking good in terms of the scale of income from such a weak instrument as this. Mr Chair, I want to return to the definitional issues around offshore person, or in fact offshore resident land withholding tax person, as is now included in clause 45.8. Because I think in here there are the two reasons I want to do that. The first of those is that I'm not sure everybody listening to this debate will fully understand the definition and who is captured by this. And then once we've clarified what that definition is, I want to raise a couple of questions for the Minister around the relationship of who is a person in terms of a trust, or who is considered a person in terms of a trust. So clause 45.8a, the new clause 45.8a, would tell you that for the purposes of this Act, a resident land withholding tax offshore person is a person who is a New Zealand citizen who has been outside New Zealand and they have not been in New Zealand within the last 3 years, or the person holds a residence class visa and they are outside New Zealand and have not been in New Zealand within the last 12 months. Now, that's actually a very important point in the context of who it is who's considered by the Inland Revenue Department at any given moment not to be a New Zealander for tax purposes, to be an offshore person for tax purposes. The idea that those who hold residence visas, of which there are many New Zealanders who have lived here for a very long time but do not have citizenship, that you only have to be outside New Zealand within the last, and not been here for 12 months. That's actually a very tight provision. It's a provision that I wonder whether the Minister wants to let us know whether that reflects other parts of tax law in terms of that. And then you have the 3 years for a citizen. And the third class is a person who's obviously not a New Zealand citizen and doesn't have a residence class visa. So we've set up there who the offshore person is. And as I say, I think a lot of New Zealanders perhaps would be surprised to learn that if they have a residence class visa but they've been away for 12 months, they're no longer considered this and then fall under the provisions within the Act here. But then if we go to 45.8b, a person that is a trustee of a trust, if they have if the trust, that is, more than 25% of the trustees of the trust are offshore persons, and then 3 is more than 25% of the people who have the power to appoint or remove a trustee of the trust or to amend the trustee are offshore persons. Here we get into the inconsistencies that are now emerging in our income tax law about exactly what is considered here to be an offshore trust. When we've got under the foreign trust rules that you can establish yourself and claim to be an offshore person, or be an offshore person and simply have a trustee who's set up to run the trust for you as a means of avoiding tax. Mr Bennett's poised because he wants to get up and talk about people who avoid tax, and that is the danger, Mr Chair, in a range of definitions about who an offshore person is across different parts of our legislation, and that's now effectively created here in 45.2. But then when we move down to what is 45.8c, we get into perhaps what I think is an even murky area, and one that the Minister and the Chair might want to take a call on. So 45.8c6, included as it was by the committee, we're talking here now about people who are RLWT offshore persons. That person is a partner in a limited partnership or an owner of an effective look-through interest in a look-through company, and more than 25% of the partner's shares or the partnership shares are effectively held by offshore RLWT persons. The rules around look-through companies were changed in this House in 2011, and they were changed by the government in such a way that those look-through companies could be zero rated for tax purposes. And that is the heart of the concern that a lot of New Zealanders now have about the massive growth in foreign trusts. Mr. Chair,
Robertson.
because those look-through companies sitting alongside foreign trusts are part of the combo pack that Mossack Fonseca have been selling to their investors. The great combo pack where you can get away without paying any tax whatsoever. And one of those parts, Mr. Bennett, for your benefit, is a look-through company that is now zero rated for tax purposes. Here we are, in this clause here, making people who have interest, if there's more than 25% of the people who have an interest in one of those look-through companies is an offshore person for resident land withholding tax purposes, then that person is considered, or that look-through company is considered a person under this Act. That is setting up yet another situation in which look-through companies potentially could be exploited. And I think the Minister and the Chair might want to get up and tell us if he's confident that, given what's been happening in terms of the release of the Panama Papers, given what's been happening here, whether he's confident that we have the arrangements around look-through companies, that he is confident putting them within this definition of who an offshore resident land withholding tax person is. We didn't discuss, I have to say, in the committee whether or not that was a sufficiently tight definition, or is there are sufficient safeguards when it comes to look-through companies. But I do know that that change has been critical in the growth of foreign trusts that are being used for tax evasion purposes in New Zealand. There's absolutely no doubt, because when you put foreign trusts alongside look-through companies who can be zero rated in New Zealand for tax purposes, that would be difficult. I'm sure, Mr. Chair, the frown on your face might indicate that there is a point at which I'm going a little beyond the bill here, but I think it is a relevant consideration, because the rules around look-through companies are now the subject of international attention, and here we are making a change about how they will be used in terms of defining offshore persons for a resident land withholding tax. So I think it's a legitimate question to be asked. Clearly, the fact that property is owned in New Zealand by one of these look-through companies may mean that that is less of an issue, but that's something that the Minister might choose to have something to say about in a moment. Mr. Chair, the other point, since I still have the call, that I will make at the moment is around the question of the information requirements, and this is clauses 44 and 45 again. And it is important to note that when we considered these matters in the Select Committee, there was a belief that information requirements for New Zealand taxpayers were clearly stated and understood, but not necessarily by those who were offshore providers, offshore persons rather. And so, you know, a series of changes have now been made to ensure that we do have that level of information. Again, this is an issue of consistency for the government. The consistency around whether or not information requirements across the Income Tax Act and the Tax Administration Act for offshore persons are consistent. And it's quite clear to me that because the government has re-looked at these particular provisions around a resident land withholding tax, they've created a series of information requirements in terms of what information must be provided to the Commissioner of Inland Revenue, and there's now a new section 54C4 of the Tax Administration Act, which will require vendors to provide at the very least their full name, address, IRD number, and whether or not they are an offshore person. If they are an offshore person, the vendor must also state whether they are associated with the purchaser and whether the disposal of the residential land is or would be considered income under the Bright Line test, ignoring the Bright Line test's home exemption. There again, you have now a series of things that an offshore person must do under this piece of legislation that we're passing here right now tonight. But those offshore persons have a completely different set of requirements and disclosures under other parts of our tax law, particularly those around foreign trusts. So once again, you know, while this might be the right thing to do to enable the implementation of this resident land withholding tax, it sets up, in my mind, Mr. Chair, a series of inconsistencies in the law about disclosure and information, which I think New Zealanders would want to see ironed out. because as other colleagues have stated, the heart of our tax system is that it's fair, that it's easy and simple to understand, and that people are treated fairly. And I think we run the risk with clauses like this that we highlight a particular type of offshore person, a particular type of investment, and not in other areas.
David Bennett.